She's lost her mind. She thinks she's a resurrected being and a god.
This is Lori Daybell's former husband, Charles Vallow, captured on police body cam expressing concern about his wife's mental health.
Her religious stuff has gone way off the deep end.
The issue was also raised by her former best friend, Melanie Gibb.
There comes a point where you got to wake up and realize there's some either mental illness there, some evil influences there.
In court documents, Gibb said Lori told her that first, Charles and then the children had been taken over by dark spirits. And here, Charles tells police his wife is threatening him.
I don't know who you are, what you did with Charles, but I can murder you now with my powers.
Less than a year after Charles Vallow's complaints, he and the children would all be dead.
So when they started to talk about zombies, you weren't really thinking anything more?
No, because they never talked about killing anyone. They would always talk about praying and hoping that the spirits would leave the bodies.
Not a lot of people that are mentally competent have a lot of stock in zombies being a real concept.
Lori's statements could be the basis of an insanity defense, but not in Idaho, where the law does not give defendants the option to plead insanity.
An insanity defense in the traditional way basically meant you could be found not guilty if you had a mental health condition.
In fact, the state is one of only 4 in the United States without an insanity plea.
Well, way back when I was Attorney General of Idaho in the 1980s, we eliminated the insanity defense. We were having in the Idaho courts an abuse of the insanity defense, in my opinion, in that it was being invoked in everything from traffic tickets and drunk driving cases.
But Lori's mental health could still play a role in her defense.
Simply asked the jury to decide, did the defendant have the capacity to commit the mental element? Psychiatric testimony is still permitted, but it's only on that narrow range of issues.
Under Idaho law, mental fitness can be addressed in a couple of ways. First, it can come up before a trial, where the court would determine whether the defendant is competent to stand trial.
If there is a mental health issue that's sufficient to prevent the defendant from understanding what's going on, a timeout will be had until the defendant is cured.
Second, the issue of mental capacity can also be brought up during the trial by the jury determining whether or not the defendant at the time of the crime was able to form the intent required.
With respect to the cases involving Lori Vallow and Chad Daybell, most of those charges are essentially general intent crimes, which means all the state has to prove from an intent point of view is that they intended the actions that they are charged with doing. So the state doesn't have a real tall hill to climb in terms of proving their intent to conceal the bodies. Where it gets more difficult for the state is if you have a specific intent crime. It's the state's burden of proof to prove the premeditation and deliberation, and that you can argue from, demonstrate that these people didn't know right from wrong or were not in touch with reality.
Still, according to experts, it is a very difficult defense to make in Idaho.
It is so onerous that it's almost never succeeds. So even if you thought, for example, that the being in front of you was a zombie or an alien, and you were doing this because you needed to protect the world, let's say, wouldn't matter because you thought about it ahead of time, you planned out what you're going to do, and you knew that your action could result in serious harm or death. So under Idaho statute, that could be sufficient elements to convict you of first-degree murder.
Still with me, the attorney for Lori Daybell, Mark Means. Mark, what can you tell us about this order to stay the proceedings and what it may mean for the case?
I can't really expand upon the order other than what the order says. There's a stay in place. There's a finding by a professional that authorized or empowered the court to make the order to stay, and the state is contesting that finding.
All right, thank you, Mark Means. I'm going to let you take a quick break, but I still have with me Mark O'Mara and Alan Ostergren, both attorneys, one criminal defense attorney, one a former prosecutor, to talk about this new development, because here, this is something probably many people expected, maybe for the case of Lori Daybell, given her past comments to family and friends and what we see in court documents. It's a little concerning to many people. I'm going to go to you first, Mark O'Mara, on what you think this may mean for her case and possibly even her husband, Chad Daybell's case.
Sure. Well, there are two separate issues that we sort of have to unravel. One has been addressed, at least preliminarily, by the judge, and that is the determination that regardless of the crime, regardless of what may have happened, that the defendant is not capable presently of actively involving herself in the defense. She's not competent. This is not an insanity finding. This is a competency, meaning, is she aware enough? Does she have the mental capabilities to interact with her lawyers? Does she know, for example, what a judge is, what the crime is, what prosecutors do, what defense attorneys do? Does she have that capacity to understand what she's being charged with? Now, the judge has said, at least temporarily, based upon whatever evidence was given and the psychological evaluation that was done, that there are legitimate concerns about her competency. Competency can be restored, potentially. What happens is, as the judge said, some restorative treatment, meaning maybe she needs to be on medication, maybe she needs some counseling, whatever it might be, to get her to the point where she can understand what's going on in the criminal case that she's involved in, and she can hopefully assist her counsel. Once that is done, it could be a month, it could be a year. I've had cases where people have gone into, on incompetency issues, have gone into a state hospital for 6 months to a year for that restoration. Once that is done, presuming it is done, then we restart the clock. Then we get ready to start presenting the criminal trial. And of course, in that case, the issue of insanity, even though Idaho doesn't specifically acknowledge insanity, which is insane to me, but that's another story, then that issue might be addressed in the way it can be addressed in Idaho.
Great explanation there. You are correct. I mean, it's different in Idaho. I looked up the statute as well. It's in like a 90-day period, then another 180-day period. And the standard was if the person becomes, I guess, restored in their capacity to stand trial in the foreseeable future is really the standard of the language there in Idaho. But also, I'm going to go to you, Alan, because here you've prosecuted many, many cases. Have you dealt with a defendant who has been declared incompetent to stand trial, and maybe how you handled that? Because in this case, in Idaho, the prosecution, Rob Wood, is objecting to this initial assessment of Lori. So what would be the next steps for him if prosecuting a defendant declared incompetent?
Sure. I mean, this is something that prosecutors and defense counsel deal with on a regular basis. The mental capacity of defendants, either at the time that the offense was committed or by the time they get to court. And I agree with Mark's excellent explanation of how it is distinct to talk about competency from insanity, but they can overlap in terms of what the facts are, and competency can be restored. And I've dealt with defendants who maybe come into the criminal justice system and they have acute drug intoxication, say methamphetamine, and they're not competent when they get arrested, but they dry out in jail over a period of, say, 45 to 60 days, and then they're going to be able to work with their defense lawyer and they're competent. When you have more serious types of, say, schizophrenia or dementia, some sort of closed head injury, those get into very difficult cases to deal with, and it can be quite prolonged. The prosecutor obviously needs to get an independent evaluation of the defendant's competency, and then the court will have to have a hearing to determine whether or not the defendant is competent. I can say in Iowa, and I presume in Idaho, but I don't know directly, the defendant is presumed to be competent. And that's an important thing. At that hearing, ultimately on a determination of competency, it's the defendant's burden to show that she is not competent to go forward. And in a case of doubt, the court would find that she is competent and the case could go forward.
Fascinating. That is an interesting point of view. Thank you both. I'm going to bring back in Lori Daybell's attorney,
Mark Means, because he obviously is licensed in the state of Idaho. And I want to ask you, Mark Means, about the elimination of the insanity plea there. Tell me a little bit more about that, and of course how I guess a prosecutor can contest incompetency of a defendant there in the state.
Yeah, on the insanity defense, I think, again, Mark said it perfectly. It's insane. It's insane that we don't have it. And then you hear the justification of a former Attorney General, David Leroy, who I have the utmost respect for, that says we eliminated it because too many people were claiming it. And what you're talking about is dollars at the end of the day. Dollars that the state was having to pay for competency evaluations for what the legislature and whatever system decided they didn't want to pay for those. And to eliminate the insanity defense that has been around since Adam and Eve, to me, is insane. It's just illogical. It's the cart before the horse, and the justification for doing it, as clearly identified, is money. And it's now that we're in 2021, I think our legislature, our court system needs to consider bringing that back. If we're one of four, obviously we're the odd man out. It's something that we need to consider, because mental illness is a serious issue. It has to be taken into consideration in any case, whether you're running a stop sign or something more serious than that. And to not have that in our state, to me, I find embarrassing.
Thank you, Mark Means. Yes, only 4 states that have abolished that. It's fascinating and excellent insights from both Mark and Alan as well. Thank you all.